fashion, and it's really a disturbing case, but a very important case because it's one of these cases where we're all guessing, what is the defense going to do? We saw yesterday the prosecution rested their case, and let me tell you, a very strong case that they have put on for the jury. And now it's up to the defense. What are they going to do? They tried to have a motion for acquittal. They tried to dismiss this case, but as the judge in this case so eloquently argued, that is not going to happen, that the prosecution has laid out a very strong case for first-degree murder for all 4 victims. And that is what we're going to talk about today. What is the defense going to do? The judge said this is the last opportunity for the defendant, Adam Matos, to make a decision about whether or not he will take the stand. He has to make a decision today about what he is going to do. We don't even know if the defense is going to put on an opening argument. We believe they're going to call 3 witnesses, but again, we are waiting to see what the defense will do. We kind of had an idea about what they were going to argue. We thought that they were going to point the finger at another suspect. They haven't really done that. We thought they were going to attack the prosecution's witnesses on cross-examination. They haven't done that so thoroughly. So we're all guessing about what to do here. Another case that we are covering here on the Law and Crime Network, and you can watch on our website, lawandcrime.com, is the Shelby Isaac case. This is the case out of Memphis, Tennessee. A 19-year-old faces 3 charges of first-degree murder in the deaths of E.J. Tate and his girlfriend, Edwina Thomas, as well as their unborn child. And this is all due to hair extensions. I'm not making this up. This is due to hair extensions. It is believed that we know that E.J. Tate and his cousin operated an establishment where they sold hair extensions and wigs. We believe he had sold hair extensions to the defendant, Shelby Isaac, and apparently she tried to steal money from him in outside of a parking lot where she shot these 2 individuals, and I should say 3 individuals because Thomas was carrying their unborn child. So it is a disturbing case. We will be covering that as well. But right now our focus is the Adam Matos case. And here to talk to me a little bit about it, because we do have live coverage in that case at around 9:30, 9:45, but in anticipation of that case, I want to bring on, and thankfully so happy to have her join us, attorney Jonna Spilbor.
Thank you for having me.
Of course, of course. Let's start about Adam Matos. Okay, let's begin.
Yeah.
The defense has a few options here. Will they put Adam Matos on the stand? Will they present an opening argument? And who are these 3 witnesses that they're going to bring on? Let's start off. Are they going to put on an opening argument?
All right, so in terms of an opening statement, what's the purpose of that? That would be to sort of give the jury a new roadmap to follow before they present any evidence or witnesses in the case. Do they need to do it? You know what, to be honest with you, the tea leaves here are so easy to read. I'm really sorry, but this is a strong, strong case for the prosecutor. It's a gruesome case for the jury. Unless there is some smoking gun, and absolutely no pun intended, I don't see what the point is. Really what we call this in the business is a slow plea. And since you can't plead if death is going to be your punishment, I think the defense here is simply going through the motions to see if maybe one juror is going to be some sort of holdout, but I doubt it.
See, I'm confused. Did they not go in with a strategy? Did they want to see what the prosecution's case was going forward? Because from all accounts, I think everyone was shocked that they didn't put on an opening argument. Fine, they have a right to reserve it.
Right.
But the fact that they didn't thoroughly cross-examine witnesses that were on the stand, and Jonna, let me tell you, they had a garbage guy on who testified to the fact that the Browns, they didn't usually have a lot of garbage, but now they had 10 bags of garbage outside of their house. There was so much room as a defense attorney to argue against that. It's speculation. You're speculating that, now Adam Matos put all this garbage out there because he's trying to get rid of evidence. What about maybe they had more garbage on some days? Are you an expert in how many times they had garbage out there? I mean, what's going on here?
Defense attorney could have done that. Would that sway the jury at all? I think when you have a case with this much evidence in favor of guilt, sometimes a defense attorney, I don't care how good you are, I don't care how long you've been doing it, you're really in a tough spot. When I had a judge one time, and I'll clean this up because we're on the air, I had a judge one time say to me after a trial that I lost, he said, look, counselor, you can't make chicken soup out of chicken excrement. That's what the defense has to do here, and it really is an impossible task. Plus, we don't know. I mean, perhaps the defendant here could have said to his counsel, I'm guilty of sin, do what you can. And if they don't have a lot to work with, then the defense doesn't have a lot to work with.
You know, we saw the judge say yesterday, tomorrow, meaning today, is Mr. Matos, she told him what it means to take the stand, what does it mean not to take the stand. You not taking the stand won't be used against you, but this is your last opportunity to make this decision, and it's your decision alone. You can't be pressured by any attorneys in this case to take the stand, and you need to make a decision. What do you think the conversation was with his defense counsel and him last night about taking the stand today?
Oh, I think that went something like this. Defense counsel said to him, "You're not taking the stand," and defendant said, "Okay." That's what I think really happened. There's no point. I don't know if this defendant is going to be likable. That would be one reason to put him on the stand. We don't know what the defendant has said to his defense counsel in terms of his guilt or his innocence. So if he has admitted to this, you can't put him on the stand, at least not in this phase. In the guilt and the penalty phase, you could, of course, and you should. So I don't know if there's any benefit to putting this defendant on the stand with so much evidence against him. He probably will get ripped to shreds on cross-examination, and then you hurt yourself in the penalty phase, which really is probably what this case is about from the defense perspective.
Let's dissect that a little bit.
Okay.
So we have had attorneys on who've respectfully disagreed, who've said that they absolutely will put him on the stand because the jury needs some sort of explanation from this guy about his behavior. And let me tell you, trying to explain away the behavior of living in that house, ordering pizza, selling their goods, escaping the area, hanging out with people while this was happening.
Right.
It's going to
ordering a lot of pizza.
Ordering a lot of pizza. Who thought pizza was going to be the biggest thing in this case? But it is.
Right.
But the people that we've had talk about this say that they need some explanation. The jury needs some explanation from Adam Matos to either explain his behavior. They need that, and maybe the way they've said it too is there's no actual physical DNA attaching him to any of the murder weapons, to any of the crime. There's no eyewitnesses actually seeing him committing these crimes. So that's an avenue for the defense to explore, and could they not put him on the stand and say, I walked into a massacre and something along those ways, but then he's going to get torn on the cross-examination.
He's going to get massacred on cross-examination. And I think you really have to weigh what the end goal here is in a case like this where even if he's innocent, let's say Matos is innocent, but right now, if the jurors had to take a vote right now, they are not coming back with a not guilty verdict, right? They're not. So as a defense attorney, you have to measure, is my goal to keep this person from getting the death penalty, or is my goal to get him acquitted? And in a case like this, an acquittal is such a long shot that I think you have to measure, do you put him on the stand to try to get an acquittal when an acquittal is impossible? My argument there would be, don't do it.
So if they do put him on the stand, what questions would you anticipate would be asked on direct examination?
Well, as you alluded to earlier, there was this sort of vague, some other dude did it defense, some third party did it.
So the idea that they put out this theory that there was a woman who was stalking Nicholas Leonard, and the idea that perhaps she was somehow involved.
So you need more than mere conjecture, right, when you're trying to point the finger at a third party in a criminal case. So if he had information about that, more information about that, I would directly examine him on that. Who is this woman? How did you know her? How do you know she was stalking? You know, what kind of history did this woman have, although the defendant's not going to know that. So perhaps those types of questions might be asked in that regard. And or you might just want the jury to see whether or not he's a human being. There are 4 dead people here. So is he going to come across as sympathetic? Is he going to be crying? Are they crocodile tears? What, you know, if they believe that he was not around when this crime happened, maybe you make a few points. But again, I don't see it enough to be an acquittal.
Is there any, I saw this in the Luis Toledo case, I'm not sure if you followed that one, but the idea, this was a guy out of Florida who killed his wife, and he killed her 2 children, an 8-year-old and a 9-year-old.
Right.
It was really, really sad to watch.
Yeah.
Put on a whole case saying he was innocent. Whole case, pointed the finger at someone else, pointed the finger at a neighbor.
Yeah.
Jury didn't buy that.
Right.
Convicted him. First thing he says on conviction is, just sentence me to death. I don't want to waste any more of the court's resources. They sentenced him ultimately to life. It was a 10-2 split by the jury, 10-1, and the death penalty 2 said no. The idea that a defendant, if he's so remorseful, still puts on a case saying that he didn't do it, and then you go into the penalty phase, does that affect a juror?
It does. But look, historically, that happens all the time, which is one of the strange things about two phases of the death penalty cases. On the one hand, you have a defense team who's going to vehemently argue against guilt for that person's client. And then once the jury comes back with a guilty verdict, you now have to switch gears and have your client take responsibility and act remorseful when for the whole guilt phase, your defense was, my guy's innocent. So it's such a strange juxtaposition, an oxymoron, if you will, that the jurors have to wrap their heads around.
There was, so I'm just curious before we throw to a clip from yesterday that I want our viewers to see. The idea here that what's been asked on cross-examination, and there hasn't been a lot of cross-examination, we talked about that.
Yeah.
But the times that they have asked cross-examination, in your opinion, is it to try to show that, I'm actually not sure exactly what they're trying to show that he's not as cold-blooded a killer as they think. He was in a terrible situation. He just committed this crime. I mean, for example, they cross-examined a detective who said, this is the only question they asked him, when you searched the contents of Mr. Matos' bag upon arrest, did he have any weapons? Did he have any guns? Did he have any knives? No. Okay, thank you. What are they trying to show here? Because, as I said, there was other opportunity to cross-examine witnesses, and they didn't do it. So what are they trying to do, in your opinion? I know it's a tough question.
The defense might know that they don't have a strong case. However, again, as a defense attorney, you don't have to just be thinking about what's in front of you right now. You have to be thinking about months down the road when your client perhaps is embroiled in an appeal. So you just can't sit there and do nothing because you don't, well, or maybe you do. Maybe you do want your client to have an incompetency claim in an appeal that might get a conviction to overturn. Now, to do that intentionally might have some ethical implications as a defense attorney, but you have to at least show up. You have to at least show that you're awake during the presentation of the prosecution's case, and perhaps that's what the defense is doing. Let me ask just enough questions to show that I'm competent and doing all I can, but I don't have a great defense, so I'm not going to attack this witness.
It's that garbage, and I thought there was so much opportunity to question him, as well as a gentleman who lived across the street. I think his name was Jim Lusk, who basically, William Lusk, excuse me. He had a canoe, okay, that was kept outside on his dock. Wakes up one morning, the canoe is on the opposite side of the canal where he managed a property, and the prosecution's going with the theory that Adam Matos took that canoe, went to the other property to escape. Couldn't you have questioned, has your canoe ever fallen off the dock before? Isn't it possible? Yeah. Have you seen any other people's canoes?
Who has access to your canoe? How easy would it be? You have cameras out there.
It drove me insane that we didn't see it. But let's actually see some of the important testimony from yesterday. There was a great witness. We've been waiting for this witness. This is the witness, Ryan McCann. I want to play you his testimony, some of his testimony from yesterday. Key witness for the prosecution. And when we come back, John and I will talk a little bit about this case as well as the Shelby Isaac case. And remember, Adam Matos, we're expecting live coverage at 9:30, 9:45, and we'll be back here with the live coverage.
Thank you, Judge. Defense, could you please turn and introduce yourself to the jury?
Ryan McCann.
And Mr. McCann, what do you do for a living?
I'm a merchant marine.
What does that do?
I'm a ship's captain. I command ships for the oil and gas industry.
How long have you been doing that for?
Almost 8 years.
So back in 2014, you were doing that as well?
Yes, sir.
And what bodies of water do you transport ships through?
Mainly through the Gulf of Mexico.
And what kind of time periods does that take you to do?
At the time, 28 days on. I work 28 days on, 28 off, so it's an even time rotation.
Okay. And back in August of 2014, where were you living?
7711 Hatteras Drive.
And is that right next door to 7719 Hatteras Drive?
It is, sir.
And I'm going to hold up State's Exhibit 254. Do you recognize your residence in that photograph?
Yes, on the left side.
Yeah, could you please point it out for us?
I'm sorry.
And is your vehicle in this photograph?
It is.
Could you please point that out as well?
It's the white F-250.
Okay. And is that a boat in the back of your house?
It is, sir.
Is that yours as well?
Yes, sir.
And that red covered area, is that your back dock?
It's my dock, yes, sir.
Okay. Were you aware prior to the events we're here to talk about today that people had moved in to the residence next door to you.
Yes, sir.
Had you met the people who had moved in at some point?
I had.
Who were you aware of that was living there?
It was an older couple, Greg and his wife, and then a younger couple, which was Megan, Adam, and a small child.
Okay. Did you have a lot of contact with them or more in passing?
No, sir, more in passing because they're right next door.
Now, was there an event back in July or early August where you came home and you would lock yourself out of your house?
Yes, sir.
Can you describe what you did for the jury and how you resolved that situation?
Yes, sir. Locked myself out, stepped outside, and the bottom door had locked. I was looking around the house trying to get to my window and couldn't find a way in.
And how were you eventually able to get in?
Adam was outside, and that's what I was doing. So I was trying to get to my home. I locked myself out, and he said he could help.
Okay. And did he help?
He did. With a couple bobby pins, he was able to get me in the bottom lock.
So he was able to pick the lock so that you could get back into your house?
Yes, sir.
Now, moving towards August 28th of 2014, had you recently been out on the boat or the ship prior to that time?
Yes.
When had you come back? What was your first day back?
Wednesday, August the 27th.
Okay, and
That
was
evening. Sorry.
August 28th, the Thursday, was that your first full day back at your residence?
Yes, sir.
And on that day, were you expecting visitors?
That day, yes.
Who were you expecting?
My brother Alan and his wife Lori.
And Alan is your older brother?
That's correct.
You take that position pretty seriously?
He does.
And that day, what were you doing in preparation for them to be coming to visit?
Well, I've been gone for a month, so I was cleaning the house, cleaning just everything up before they got there, of course.
Okay. Over the course of the day, did you come into contact, in the daylight hours, did you come into contact with any of the people next door at 7719 Hatteras Drive?
I did,
Who'd you come into contact with?
with Greg.
And Greg is the approximately 50, 52 years of age
Yes,
man that lived next door?
That's correct.
What approximately do you think was the first time you came into contact with him on the 28th?
About 10 a.m.
And what were the circumstances of that?
I was running around getting the boat ready, getting the top up, put the seats in, and he was on the back porch.
Okay. Was there a subsequent contact that you had with Greg that same day?
Yes, sir. He asked to borrow a ratchet to fix something on his RV.
All right. Did you have any understanding of what he was doing with the RV?
He said he was changing the spark plug in the generator.
Approximately what time did you lend him a ratchet?
Approximately 4 o'clock in the afternoon.
4 o'clock in the afternoon. And did you ever get that ratchet back?
No, sir.
Did you ever see Greg again?
No, sir.
Now, I want to draw your attention more to the evening hours. Was it your understanding that your brother Alan and your sister-in-law Lori were delayed in their trip?
They were, sir. They had a flat tire.
And were you in phone contact with them as they were traveling?
Yes, sir.
During the later hours of that day prior to Alan arriving, what about were you doing?
Prior, I was cleaning again. Yes, sir.
Okay. Cleaning, did that involve vacuuming?
Yes.
Were you doing anything else while you were cleaning?
Well, I had the music up pretty loud. Yeah.
Okay. Was it loud enough so you'd be able to hear the music over the vacuum?
Absolutely, yes. Yeah, pretty loud.
Because that's the way guys vacuum, right?
That's right.
If there had been loud noises next door, based on what you were doing and the noise that you were generating and doing it, would you have expected to have heard that?
No, sir.
Congratulations.
Sustained, if you want to re-ask the question.
If there had been loud noises next door, because of the music and the activities you were going about, do you think you would have been able to hear the noises over what you were doing?
Objection, speculation.
Overruled.
It was very loud. I wouldn't hear anything besides what was inside my house.
And were you trying to pay attention to things that were going on next door?
No, sir.
Now, when Alan and Lori finally did arrive, do you know what time it was?
It was after midnight, 12:30.
Now, 12:30, is that a time that after all this happened, you were able to go back in your phone and check your phone log with regards to when you had spoken to Alan in order to nail down that time?
Yes, I spoke to him, and also he texted me, so yeah, I knew what time he...
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. You were watching the prior testimony of Ryan McCann in the Adam Matos case, a key witness in that case. We're going to keep playing some of his testimony today. Before we go to live coverage, I think at around 9:30, 9:45 in the Adam Matos case. Big day for the defense. The prosecution has rested their case. Now it's a question, what will the defense do? Here to help me answer that question is attorney Jonna Spilbor. Let's talk a little bit about what the defense will do. We keep talking about it. We think they're going to call about 3 witnesses if they decide to put on a case.
Yeah.
What kind of witnesses do you expect that they would bring up? I mean, is one possibly to try to talk about this Michelle Stinson character, this woman who was allegedly stalking Nick Leonard?
I mean, look at the possible viable defenses here. One is somebody else did it, right? Because all we really know right now about this defendant is, I guess his claim is, wasn't me, I wasn't even there, right? Even though we know that he lied to the police and there are a whole lot of dots that have been connected, he certainly had the motive to do it, and there's some, other weird circumstances that would lend itself to point the fingers at him. But if they have something that will take the jurors' minds off him and say, well, wait a minute, even if you can't quite prove that somebody else did it, if you give the jurors enough of a reason to say, well, now we're not 100% that this defendant did it, you either get a hung jury. I seriously doubt you'll ever get an acquittal, but you might be able to have 1 or 2 people who say, I'm not convinced now. It could have been somebody else. So perhaps that's where they're going to go with these witnesses.
Yeah, it's it's funny to say a reasonable doubt.
Yeah.
Reasonable doubt. What is reasonable doubt? And I think the thing for them is, what I found interesting is to introduce a new character to this. And we saw previously the defense trying to do that when they were cross-examining Daniel Leonard, Nicholas Leonard's father. They said, do you know Michelle Stinson? Objection. This is outside the scope of his testimony. That was a fair objection, but they couldn't bring that in.
Right.
It's different than a case where we had, and I keep bringing it up, where we saw the Aaron Hernandez case, and we had Alexander Bradley, who was the star witness for the defense, for the prosecution, excuse me. But he was a character that was intimately involved in that series of events, and you could point the finger at him. Here, she just, no one knows her. She just comes into this scenario, and you're going to point the finger at her. Problem, I think.
And it's almost akin, it reminds me of, if you can remember way back to the Scott Peterson case.
Sure.
When they the defense tried to float, hey, there was other people in the neighborhood, there was a robber, there was a band of gypsies or whatever they said, and the judge kept saying, nope, 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 you don't have enough to point your finger at a third-party defense. So even if, so let's say they try to bring something up like that on in their defense case, judge might shut it down. You know the prosecution is going to be objecting the entire time if that's what they do. Otherwise, I'm at a loss. Who are you going to bring?
I have one theory about who they might bring or what we've been talking about. And before we get to that, I mean, it is different than where I saw the Jessica Chambers case, where that case, I mean, really gruesome. But I was not 100% sure that Quentin Tellis was the one who did it. I mean, this is a guy where the victim spoke the name of her alleged attacker, someone that wasn't Quentin. It was everyone thought she said an Eric or Derek. There were Erics and Dereks in the area. Right. What did it mean for the police to investigate certain people and exclude them as the actual suspect? I had so much reasonable doubt there that the jury actually, it was a hung jury. It was a mistrial in that case. So this is a little bit different. I wonder, today, would they bring on somebody like a law enforcement official who would talk or testify to maybe gunshots or maybe individuals in the area who heard gunshots? Because what I kept hearing was that the idea that there were witnesses who walked by and heard gunshots from the Browns' house, and they thought that it was happening at a later time around 11:45 midnight, poke holes in the prosecution's timeline of events. You say that, but isn't it possible people in that area were firing guns? I mean, I think there was a nearby farm. People were firing guns. It wasn't uncommon to hear people firing guns. So how do you know if that gunshots actually came from that house? And poke holes in that timeline. Maybe is that a way to do it?
You know, poking holes in the timeline might not be a bad strategy. But for my homework, I think it wasn't, these people didn't simply die from gunshot wounds. He bludgeoned their head, or somebody bludgeoned their heads with hammers. So it's almost like, well, if the juror could easily dismiss that and say, we don't really care about the timeline. We also know that there was blunt force trauma, and we're still putting this defendant in the house at or about that time. But you're right. I mean, they have to, if they're going to present a defense case, then present a defense case. And again, maybe they're going to have, their best theory is he didn't do it, somebody else did, and whatever they can bring to try to convince a jury that the police got it wrong, unless maybe they'll bring a police officer back up to poke holes in the investigation that they weren't able to do during direct examination in the state's case, perhaps.
And that's why I think it's interesting for the prosecution, because we always hear after the certain witnesses testified, are they still subject to their subpoena for recall? Because they don't necessarily know what the defense is going to do.
Right.
I think they're going to be surprised. And I'll tell you, from a law and crime perspective, from anybody who's watching, today is certainly going to be interesting. One way or another, I think everyone's going to be surprised. I think it's going to provide some very exciting testimony which way, or strategy-wise, how these lawyers maneuver this case.
You know, one thing is for sure. We don't know anything right now except one thing. These jurors want to hear from him.
Oh, absolutely.
Even if they think he's dead to rights right now, they always do. They always want to hear from the defendant. It doesn't always help, but they want to hear him speak.
Now, we saw in the Jeffrey Willis case, this guy out of Michigan accused, I mean, the details of that case were ridiculous, and he was actually 3 mini trials in one, because he was accused of 3 different crimes, and they said he had a pattern. He took the stand, didn't work out so well for him, he was convicted. Just can you briefly speak about some of the dangers of a defendant taking the stand in general? We know that perhaps he has a record in Pennsylvania. There's certain the idea of that he has been convicted of certain crimes. That idea will be brought in possibly. Just the dangers of a defendant taking the stand in general. 2
big ones that come to mind immediately. Number one is, just as you said, if you have a defendant with a troubled past, so to speak, whenever you have somebody on the stand, their credibility is automatically an issue. So you can ask, as the opposing party, you can ask questions that normally would not be revealed simply because you put that person on the stand, and now it's fair game. So that's danger number one. If you have somebody with a sordid past, you might not want them on the stand. Danger number 2 is when you have somebody who's an expert at cross-examination and you have a client who's not an expert at testifying. That's like oil and water, right? So you never know what is going to come out of any witness's mouth, let alone your client's mouth, when they're subject to cross-examination. And if one thing goes wrong, can I give you a really quick story? All right, here's one thing that I witnessed go wrong myself in a trial.
Okay.
Had a witness who was adamant about something that occurred on a specific day. And the reason she was adamant about that is because she was putting her kids on the bus, and she always put her kids on the bus at this time, at this day. Okay, great. Well, it turns out the crime in question happened on a Saturday.
I was just thinking that.
Happened on a Saturday. Boom, done, end of, and you can't put that horse back in the barn.
Nope.
So
attorneys didn't catch that beforehand?
Nope.
Oh, man. So you're not representing them. That's the problem.
No, right.
That's the problem. That's what
I
it is. Before we go into our further discussion of Adam Matos, I want to briefly tease and talk about the Shelby Isaac case and get your quick opinion about that. Again, this is a case out of Memphis, Tennessee. Shelby Isaac, she's now 19 years old, but this crime occurred when she was 18 years old. She faces 3 charges of first-degree murder in the deaths of E.J. Tate, his girlfriend Edwina Thomas, and their unborn child. A horrific shooting that seemed to be as a result of hair extensions. Apparently, Mr. Tate owned a business with his cousin that sold hair extensions and wigs. According to the prosecution, it was Isaac who purchased these hair extensions, but really wanted her money back, and it seemed to be a robbery, a horrific killing and robbery. So I want to talk about briefly this case. We're going to be streaming it on lawandcrime.com. the prosecution seems to be resting the majority of their case on this this Victoria CA who was indicted on charges of aiding Isaac. So her collaborator, not somebody who helped her,
Right.
person who aided in this crime. The dangers there of resting your entire case on somebody who was involved in this crime, I have to imagine that's not great.
No, it's not great because their credibility too. I mean, are you lying to save yourself from a harsher penalty, which is typically the case, or are you the actual perpetrator and you're lying to get the heat off you? Is another scenario that can happen there. So the police and prosecutors are going to have more than simply that. Let's call her the getaway driver for now. More than her testimony, I think, in order to get a conviction in a case like that.
Yeah.
Plus, what makes that case so sad for me is, so she's being charged with a triple murder because one of the victims was, they said, 6 to 8 weeks pregnant.
Yeah.
And in that state, not in every state, in that state, you can be charged with homicide regardless of the age of the fetus. It's at any age. Whereas certain states, you have to be pregnant for a certain amount of time in order to be charged with that. So
That's why
makes
this
it
is a
extra
triple
sad.
homicide.
Yes.
It's triple homicide, as horrific as it is. Briefly, the idea, the motive behind this crime that has to be involved with hair extensions. I will tell you, we have an article up on lawandcrime.com. It's about this case. And we've reported that, believe it or not, thefts of hair weaves or extensions are a problem in several cities. It claims Memphis alone saw 13 thefts over an 11-month time frame, and the merchandise stolen in that string of incidents was close to $20,000. Now, what we believe here is it's related to hair extensions, that she was trying to get her money back, that she bought hair extensions, but the idea that this is what it's about, what do you make of that?
I mean, obviously it's senseless, right? In a word, it's absolutely senseless. But I don't think we're quite sure yet whether her motive was she wanted hair extensions that she could sell on the street because they are valuable, or whether she was a disgruntled customer. You would almost think that a disgruntled customer has their rant inside the store during business hours, right? If you're, hey, I want my money back for these hair extensions, it's going to happen during normal business hours. Otherwise, did she stalk these people? Like, what was her, I think that's going to have to come out in the course of this trial, what her true motive was there in terms of this robbery.
I mean, it's really disturbing to hear. So let's actually, we're gonna play some of that testimony from Adam Matos, because again, the Shelby Isaac case, you can follow that on lawandcrime.com, but our focus here today is the Adam Matos case. We expect live coverage at around any moment now, maybe now in the next 10 or 15 minutes, maybe even shorter than that. So in the meantime, I do want to play you some more testimony from yesterday where Ryan McCann took the stand, a key witness for the prosecution, somebody who was hanging out with Adam Matos during this whole time frame. So as we wait for our live coverage, in the meantime, take a look at this clip.
Actually, to indicate that he had arrived?
Yes,
And when you did that, did you go outside and greet him?
I did.
When you went outside to greet him, was Lori with him?
Yes.
And did the two of them come alone?
Yes, sir.
And real quick, at that time, back at your residence, was there anybody living at your residence with you?
No, sir.
So it was just you at 7711 Hatteras Drive.
That's correct.
When you go out and you meet with Alan and Lori, did anybody else show up?
Adam, the next door neighbor, showed up.
Did he come from the general direction of 7719 Hatteras Drive?
Yes, sir.
How did he appear?
He was sweaty.
Did you find that unusual based on the weather that night?
Yes, sir. I mean, it was it was a summer night, but it wasn't very hot, so.
Okay. Was Adam fully clothed?
Shorts and a t-shirt, yes.
So he had a shirt on.
Yes.
And were you helping Lori and Alan get their luggage in so they could stay?
Yes, sir.
And as you're doing that, what did Adam Matos do?
He was there, and he, like I said, he showed up, and so we're getting things out, so I introduced him to my brother and my sister-in-law.
Okay. When you guys go in the house, what did he do?
He followed in behind.
Did you specifically invite him in?
No, so I was just carrying stuff in. So
Did anyone say, "Hey, Adam, come hang out with us in the house or in the back"?
no, sir. Not Robert.
But did he follow you into the house and go with you towards the back dock area?
Yes, sir.
Did you guys hang out for a period of time that night?
We did. Show my brother the house and then the dock. Mostly, yes.
Okay. And did there come a point in the evening where well, do you know approximately how long you think you and Alan and Adam Matos were hanging out in the back area of your residence?
We were there probably till, my brother and I were out there till probably 1:32 in the morning. Maybe.
Okay, and of that time, was Alan there the whole time? I mean, was Adam Matos there the whole time?
No, sir. He was
Approximately, when did he
probably
leave?
about 45 minutes, 30, 45 minutes.
And when he left, what direction did he go?
Towards 7719 Hatters.
Now, I want to, you said you and your brother are out on the dock. After that, you go to sleep.
Yes, sir.
You wake up the next morning, probably a little later in the morning.
No, not that morning, no.
Okay,
About 10.
okay. And so the next day, that'd be Friday, August 29th.
Yes, sir.
And did you have to do anything with Alan's car that day?
Yeah, yes, sir. We went to Walmart to get the tire fixed.
Did you go out to eat for lunch?
We went and grabbed some lunch while I was getting done. Yes, sir. Grabbed some bait.
And you grabbed some bait. Why'd you grab some bait?
Going fishing.
When'd you go fishing?
Right after we got back, probably around 1.
Did you catch anything?
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. We have a live feed right now in the Adam Matos case. Trial hasn't started yet. The attorneys, the judge is gathering some things in preparation for the trial, but we wanted to bring you a live feed as we go to it. I'm joined today by attorney Jonna Spilbor. Jonna, you're watching this feed right now. You're seeing Adam Matos. We believe the very first thing that he is going to be asked is, are you testifying? Are you testifying? This is make or break time.
It
and
really
what do you
is.
think? What, I know we keep talking about it, but for anybody who's joining us, what do you think the decision's going to be?
You know, I'm going to go with no. He's not going to testify. Although let me add one more thing, because this was the first time I really got sort of a good up close look at him. Let me ask you a question.
Sure.
Do you think jurors base any decisions on the appearance of a defendant?
Absolutely.
You do.
Absolutely.
And if you were in the jury box, does he look like a murderer to you?
John, I'm so glad you brought this up, because at the beginning of the trial, one juror had to be dismissed because they thought he was too good looking. They
Wow.
thought he was too good looking. Now, I mean, that happens. You have defendants who are attractive to people in the jury room, and that can be prejudicial. Luckily, they were able to weed this juror out, but that is 100% true. I think when we covered the David DJ Criado case out of New Jersey, you had this father with a beard, a long ponytail. It was discussion that he was in the occult. He believed in supernatural forces.
Right.
That affects a juror. They see this guy. There's a reason you shave your client, you put him in a suit, because appearance matters.
I guess most people do judge books by their covers, especially when that book is sitting at a defense table in a criminal trial. He looks, not that there's any stereotypical look to a murderer, but they've got him cleaned up very well. And,
Yeah.
I've not heard him speak, so I don't know if he's softly spoken, articulate, not articulate. I don't know that. His defense attorney does. So I'm very interested to see what happens here.
We heard him speak a little bit yesterday to the judge, very briefly, like, do you understand what happens when you testify? Do you understand that it won't be used against you? How old are you? Things like that. He seemed very soft-spoken. I think that also might have to be with nerves. The guy's on trial for his life right now.
Yep.
And I wonder, what's interesting to me is how many times defendants don't realize that their actions are caught on tape. So we saw numerous amounts of testimony this week of surveillance footage of him buying a shovel in Walmart, of him cashing checks, of him buying items, using the Browns credit cards, checking into that hotel where he was eventually apprehended. So the idea that how many times defendants don't realize that their actions will be replayed in a courtroom.
Yeah. No, well, that's, we call that also, felony stupid. I mean, people, and you don't realize it. And let's take it to another level. If you're a defendant at a defense table in such a serious case or any case, jurors are going to look at you. So do not laugh at inappropriate times. Do not fake cry ever. Jurors can pick, and they're gonna want to look inside your soul, so to speak, and see if they can figure something out that nobody else can figure out. So, the best bet is to just look straight ahead, take your notes, talk to your lawyer, that's it.
Yeah. If he doesn't take the stand, because I kind of see this happening since I've been surprised. If the defense says, you know what, Your Honor, he's not going to take the stand, we're not going to put on a case, what happens in that kind of scenario when they really weighed all their options? Because I could be wrong, but I think I remember yesterday they wanted to consult with the prosecution about the charges and the penalty and what he might be facing. I know they probably had that discussion with him. What would happen in that kind of scenario?
All right, so unless there's some backhaul deal where the prosecution has had a change of heart and they're willing to allow him, the defendant, to live. In other words, we don't need to go on to, well, we'll strike a deal, won't go on to the penalty phase. That would be a win, in my opinion, in this case. Otherwise, what this defense attorney has to do is get up and rock that closing argument using only the evidence that was called during the prosecution's case.
Yeah.
That's not always easy to do.
We saw discussion on the chatter boards about, because the defense hasn't been doing much, is this an ineffective assistance of counsel claim later on?
Right.
But I don't know if that's necessarily fair, because the defense might have had a strategy here, they might still have a strategy here about what they want to do. But does these kind of cases where you see something the defense could have done more, maybe they weren't acting in the best interest of their client, have you seen ineffective assistance of counsel claims like that?
You can bet your bottom dollar that anytime you have, and it'll be an automatic appeal on a death penalty case, when you have an appeal, ineffective assistance will be one of the claims in that appeal. You can bet your bottom dollar.
I'm sorry, Jonna, I think we might have some audio.
Yeah, judge is talking, but
Oh, okay. Okay. I thought we might have had audio still, but my correction. All right. I thought we might have heard something. Okay. So again, we are waiting for the defense here to determine what they will do. Okay. I think we actually do have our audio, so let's go to it right now.